stay within his or her time or even cut it short. So we should just congratulate them right here and now, and we do not intend to violate that same precedent that's been set. So by way of introduction, I'm Phil Favreau. I am a discovery and information governance consultant with Driven, which is based in Falls Church, Virginia. And I'm joined by a star-studded cast here as my panelists. And I might add that I'd love to have I would love to have the 4 or 5 of the other people join us, but I don't think we have enough basketballs to go around. Everybody in this team wants to shoot, and there's only one basketball. Otherwise, I'd have 9 or 10 up here, and I think, like you had said, Casey, nobody will end up saying anything because it'll be so quick. So we've decided on these 4 for today, and I want to introduce Craig Ball. Craig is a forensic specialist. He is a board-certified trial attorney, and he's a fantastic human being and does a great job of articulating why it is that we need e-discovery competence. Craig is going to talk to us about search today. Stacy Blaustein is corporate litigation counsel for IBM, just a small company based in Armonk, New York. It's been around for a couple of years. You may have heard of it. Stacy has quite a bit of experience both on the plaintiff's and the defendant's side litigating. She has a great understanding of what it takes to be competent in the areas of e-discovery. She's going to be talking to us briefly today about collection and competence in collection. Judge James C. Francis IV. I got your middle initial right, finally.
You did.
Yeah, well, there's a first time for everything. Judge Francis has been a federal magistrate for, I believe, over 3 decades, based in Manhattan. He has unqualified, I should say, his expertise in this area really is unqualified. He has very articulate views on the issues, and he could speak to any of these issues we're going to focus on today, but he will be focusing on preservation and competence of preservation. And last but not least is Gail Goddard from Axon Veltrop. She is based in the Hartford, Connecticut area and also works out of the firm's Midtown Manhattan office. She has quite a bit of experience in the litigation arena. She's a partner for her firm. She's going to be talking, and I should say, Jay is going to be talking about proportionality. Sorry, I don't mean to cause you a heart attack, though I'm sure you could deal with preservation.
Which I'm going to do later.
Which you're going to do later. Hence my confusion. And then Gail is going to be talking about preservation. And we're going to be going in the following order. Judge Francis is going to talk about proportionality and how it is that proportionality overlays all these concepts, preservation, collection, and then search. And then we're going to go in that order. So from Judge Francis to Gail, to Stacy, and then to Craig. But for the benefit of everybody here, I need to be a lawyer for just a moment and put up the appropriate disclaimer. And I won't read it to you in a very quick voice like they do on computer ads, I promise. But, or I should say television ads. But please, you don't have an attorney-client relationship with Gail, certainly not with the judge or anybody else here, based on today's presentation.
I am your lawyer, however.
Yes, yes. He could be your lawyer.
You'll get a bill.
But I do recommend hearing what they have to say. Again, they're very erudite, insightful, but in a practical way. So let's go ahead and transition over to the concept of proportionality. How many of you have heard of proportionality before? That's better than I think we see at most audiences, is it not? Okay, who could give me a good understanding of proportionality, a good definition? Could I pick on one of you? Go ahead. Do what you need when you need to do it, okay? I'm not sure I agree with that, but that's one way of looking at it. Let me go one other definition. Go ahead. Okay, the amount of information you keep on a given case. Okay, that's one way of looking at it. And to be fair, I don't know that I agree with that too, but good job. I mean, we're calling on you just on the spot. One last one. Beth, go ahead. Okay, what do you think about that one, Judge Francis? I'm going to turn the baton over to you.
Sure. Well, we're certainly honing in on it, and let me start, I guess, by getting everybody on the same page by telling you what Rule 26 B1 now says about proportionality, and then I'll talk a little bit more about my views and open it up to the panel and to the audience, because I want this to be a more interactive panel. In the last round of rules amendments, the Rules Committee moved considerations of proportionality from the section dealing with protective orders up into the very definition of what constitutes discoverable evidence. And it says that discoverable evidence includes that which is relevant to any party's claim or defense and proportional to the needs of the case, considering the importance of the issues at stake in the action, the amount in controversy, the party's relative access to the relevant information, the party's resources, the importance of the discovery and resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefits. So that definition, I think, incorporates the definitions that each of you offered as well. And let me offer some thoughts about the significance of that change, particularly as it relates to the competence of counsel. I divide competence into legal competence on the one hand and what I call practical competence on the other. Legal competence, obviously, is understanding what the law says, what it means. And I think there are a couple aspects of proportionality we need to keep in mind. The first is just know that the concept is there. It has been in the rule, as I said, in the protective order section for years. And yet I have seen very few parties utilize the proportionality concept. Even in circumstances where a producing party is clearly unwilling to produce information because it is so burdensome. But instead of saying it's disproportionate, they say it's irrelevant. Well, it's probably not irrelevant. That is a different concept. It may be relevant under the broad definition of relevance under the rules, but it may be disproportionate. So be aware that that tool is out there. And from the requesting party's perspective, anticipate it. You have to understand that your adversary may well make a proportionality argument when that party is asked to produce information. And I think there are two consequences. Number one, when you formulate your discovery requests, you have to keep proportionality in mind. And secondly, after you've done that and you are expecting a response, you have to anticipate that that response may be, this is disproportionate. And you want to start to think about the arguments that you're going to use to rebut that. You also need to be prepared to address those factors that I just ticked off. Not just cost and burden. We often think of proportionality as a weighing of cost and burden, right? Sort of marginal benefit. Well, that's really only one or two of the factors in the rules. You've got to be able to think about all of the factors, and indeed you've got to be able to make arguments to the court about how those different factors get balanced. Good luck, right? I mean, these factors aren't measurable on the same scale. You can't talk about the importance of the issues in a case necessarily on a dollars and cents basis. So you've got to make an argument about why in this civil rights case it is or is not disproportionate to ask for this information.
Judge Francis, let's step back and look at it in a practical context, and let's take it out of the rule book. Privilege logs, for example. If I came to you, you're the judge, Craig and I are representing respective parties in the case, and I tell Craig, look, there's way too much information here that's subject to discovery but is non-privileged, that I don't really want to do a line-by-line designation of each document, each email in an email string. I'm going to propose to do it by category. And Craig says, no way, no how, I don't care what the rule comment says, you're not doing it by category. And I move for a protective order seeking court permission and saying it's not proportional to do it Craig's method. I'm going to adopt a proportional and reasonable fashion. Tell us what your reaction is to that, and then Craig, if you can give us your reaction as well, and the ladies too.
Well, my reaction is that a categorical log makes good sense in anything except the most simple case. The difficulty from my perspective is formulating a way to to police it. That is, I understand that you're going to say that all of these documents are privileged because, and you're not going to go through the usual detailed information on each one. So how am I going to know as the judge whether you're doing that honestly or not? And in partial answer to that, one technique I've used is simply to take a random sample of the documents that the party has logged categorically, examine them in camera, and if they conform to the description that the party has given them, and that's privileged, that's fine. If they don't, they lose the privilege for that category.
Okay. Any reactions to that in connection with privilege logging and proportionality?
I can't improve upon that answer. I would only add that one thing that has changed in dealing with this is it's a matter of trust. If I felt your bucketing mechanism were trustworthy and were as likely to truly get the privileged material and leave me the discoverable material, I'd feel fine. It used to be that my lack of trust would be based on character. I would, as I did in a small town where I practiced called Houston in Texas, I would know who I could trust and who I couldn't trust. But today, there's a new factor in mistrust. I may trust your character, but I may not be able to trust my opponent's competence when it comes to the mechanisms they're employing to segregate electronic information. And so that's the thing, as Judge Francis said, how can I police this? How can I build trust into this to overcome my opponent's overwhelmingly common lack of competence in this area?
And that's complicated in situations where the parties are asymmetrical, where there are similar parties where there's going to be a large volume of privileged information that may be at play on both sides. Trust is almost a necessity. On the other hand, where you have an asymmetric case where only one side is producing a categorical log, then you need something else.
Okay. Any other comments, Gail and Stacy, on this before we move forward with Judge Francis's further remarks?
No, I completely agree with Judge Francis. I think, if the party that's purporting to use the log can prove their credibility either through a random sampling, in-camera inspection, I think that it's definitely a more reasonable and proportionate means to disclosing what's being withheld on the basis of privilege.
Okay.
I think as a practical matter, too, part of the policing goes to the fact that if you're the party, don't overplay your hand. This goes to candor and competence, because if you overplay your hand and Judge Francis does an in-camera review and sees that you were cheating on that privilege log, you're losing a whole lot more than that category, because you never want to be in front of him again, because it says a lot about you. If you're willing to cut corners on that, the worst thing you want to do is lose your credibility with the judge early in a case over a discovery motion. It's devastating. You will not recover. And luckily I've not been on the receiving end of that, but I've been on the side where I've challenged a privilege log and had a judge find that clearly non-privileged documents were being logged. And it definitely hurt the other side, because it just proved, rather than me saying, Your Honor, I'm producing everything and I'm not getting anything, how can these emails be privileged? And then once it was demonstrated, it really kind of changed the momentum in a case a little bit, because you're only as good as your word. And that's competence, candor. That's the bottom line, I think, across everything. We all make mistakes. Technology is complicated. It's very hard to keep up with it. But if you're honest and you have to go in and say, Judge, I'm sorry, I made a mistake, I didn't catch that snafu on the computer, you're a lot better off if you have a good reputation and you're a straight shooter, as opposed to somebody who's going to, cheat on a privilege log. That's just my perspective.
So would you agree then, we're not going to transition to Gail's point quite yet, but do you agree with Judge Grimm's statement, Judge Rosenthal's statement, I should say, that what is preserved and produced in discovery turns on what's reasonable and what's proportional then? And is that accord with your understanding and with your other points that you have?
Well, and it accords with the rule, absolutely.
Okay.
Let me turn very briefly to practical competence. Even if you know the law, you've got to be able to implement proportionality when you get in front of the court. I've got far too many cases in which a party will say, Your Honor, this is simply disproportionate because we're a small company. That doesn't help me. I've got to know with some detail what costs you're actually going to incur. I need to know what your burdens are, which may mean that you need to know what your computer architecture is and why it's going to be difficult to extract this information. You also need to do an analysis to figure out whether it's really going to be worth making the argument, right? It's going to be somewhat costly and time-consuming simply to present to the court what you're going to need to make your proportionality argument, and those transaction costs may end up outweighing the marginal benefit that you would get from withholding additional information. So you have to go through that analysis at the outset. And finally, I'd say, proportionality is not necessarily a zero-sum game. You ought to be thinking about ways in which to make the process more proportional. And this goes to the categorical log issue. Think about whether sequencing discovery might make it more proportional, whether taking sampling rather than disclosing an entire universe of information would make it more proportional. So those are the practical kinds of things, I think, that make up competence in this area.
And I think that when you're in state court, maybe your state court judges, you feel like your state court judges are not as sophisticated as, say, your federal judges. What's the general consensus from the group on that? Who's more sophisticated, state or federal? Raise your hand if you say state. Raise your hand if you say federal. Okay. Okay, and look, that's no disrespect to our state court judges either. But I would probably say that that's the case in California, where I practiced for many years, and also in Utah. Educating our judges on these issues, if they're not educated on issues of proportionality and technology, is part of our duty of competently litigating. Let's transition to preservation. And look, we could go any number of ways in terms of competence with preservation. But Gail, what are some of the highlights that you think our audience needs to hear? And let's hear from other panelists too, what they think after you're done.
Sure. So the duty to preserve, it sounds simple, but it's the question that I get really frequently from clients, either ones who've been lucky enough not to be sued before and are implementing a litigation hold for the first time, or ones that just have, it's a nuance. It's not as clear as you would think. So you don't, this goes to proportionality as well. You don't have a duty to preserve everything forever. It's the figuring out where within those categories you can narrow. So it's good to have routine disposal practices with the understanding that if you're sued or you reasonably anticipate litigation, you have to suspend those. And again, that goes to competence, because you have to know what you have to know what your deletion practices are. I think as lawyers now, we can't say like we used to, the IT guy knows. This is much more than the IT guy's area. You have to know what your systems are, what you're keeping, how you're keeping it, and you have to know your whole litigation portfolio. So you have to, the obligation, the duty is to preserve relevant information when a lawsuit or an investigation or other legal or regulatory proceeding is reasonably anticipated. So if you're the plaintiff, you certainly have to have a hold in place by the time that you're filing a complaint. Most likely, it could go back a long time before the complaint, when you started planning the litigation. And a lot of times we see that plaintiffs, I generally defend larger companies, but where plaintiffs have clearly been emailing and talking to people in non-privileged conversations about potentially suing somebody, and they're not preserving their own documents. They're clearly anticipating litigation.
Let me interrupt you just for a second. What about the defendants who try to get a little bit too clever with their privilege logs and assert work product protection going back in time 5 or 10 years? What's your reaction to that with the duty to preserve?
You have to be very careful about what privileges or protections you assert, because if you're trying to assert work product or that it's privileged because it was anticipation of litigation, you better have a contemporaneous legal hold, because otherwise you are shooting yourself in the foot. And I actually had a case with the state of Connecticut where their counsel did that they claimed privilege going back 5 years and they didn't have a hold in place and they didn't have documents. That is, there's no way around that.
It's elementary competence. How many of you have some sort of process in place to ensure that when you have a log and you make a work product protection claim, that it coincides with the date that you began preserving evidence? Okay? We've got a few of you. Okay, that's great. That's great. But every hand should go up in the room. Again, this is basic elementary competence because, I mean, the Ciani case came up in not in front of you, but in your court in the Southern District. And the judge reasoned very, very straightforward fashion. The duty to preserve is triggered with the anticipation of litigation. And that's exactly the same trigger for work product. The duty to preserve was backdated a number of years because of that. What other tips do you have, Gail?
So trigger, as Phil mentioned, that's huge. So sometimes the trigger is obvious. If you're, or more obvious, if you're a defendant and you don't envision that you're going to get sued, you think you're conducting your business completely legally, you don't know that you put barrels in the ground somewhere that might leach or something like that. But so you just get a complaint out of nowhere, let's say hypothetically. Receipt of that complaint is the trigger. At that point, you certainly have to put your hold in place. But if you're a manufacturer and maybe you know that there are some drums that you buried somewhere and it's not a super fun site yet, but it could happen, then potentially you have to be thinking, is there a trigger out there because something could come up? If you get a notice from the government of an investigation or you get a subpoena and you think you may be the target of an SEC investigation or something, even if you haven't been notified that you're the target yet, or if you're in an industry that a lot of people are being investigated for, like a financial services industry, even if they haven't found you yet, it's a little more gray, but should you be preserving? And a lot of this, it makes it seem so defensive. You should be preserving because it could be the evidence that helps you successfully defend yourself. And one of my concerns is that discovery has become such a defensive exercise. I don't want to give the other side something because they want it. I want to reduce my costs is a legitimate thing, but there's this resistance, like I just want to give enough and not get sanctioned. But the fact is, we don't try enough cases, but if you try a case, what's your evidence that's going to get you off the hook as the defendant or as the plaintiff that's going to prove your case? Don't be so hasty to not give over information because you may need that. And this has happened to me, unfortunately. On the eve of trial, you may not be able to introduce a document that you want to introduce because you asserted irrelevance or something and stood on that and didn't produce it to the other side.
Is your big firm the other side? You'll get nothing to like it? Is that kind of...
Pretty much. Well, in my case, I inherited from another firm, but yes. But just as a qualification. But it did lead to, we couldn't call a witness because I couldn't rely on a document that I needed the witness to testify to in a state court trial in Connecticut. But I think we need to see it. Don't be so hasty to say you can't have financial records because they're my financial records and they're sacrosanct. Think about a confidentiality agreement. Think a little more broadly as, we may hopefully eventually reduce the cost of discovery so we can try more cases. And then we're actually going to have to introduce evidence. And that's what discovery really is supposed to be leading to. So, don't harm yourself, especially if you're likely the defendant and you have a lot of documents and you are drowning and you're thinking, I have to come up with more. But really think, what are the claims and defenses in this case? What's the evidence going to be if this goes to trial or even on a summary judgment motion? What proves my claims or defenses? Make sure you have those documents and that those are produced. Even, maybe they're not asked for so clearly. You want to make sure you produce them either response to Rule 26 or you make sure that those documents are in. So again, that's another thing, being careful about the trigger and the scope of what you produce. That's the greater picture here. I'm sorry, do you have a question? Yes.
What about non-litigating third-party preservation notices, especially those that must go to law firms or third parties and/or the opposing party?
That's tricky. It also includes now cloud providers and vendors who may have your data, all sorts of things. The third parties that's tricky, and there's more case law out there. You're likely, depending on your contract with them, but in most cases, as long as you have a right to get that information back, you're likely, I think, and Judge Francis, correct me, to be found to be that's in your custody or control, and that you, in an abundance of caution, want to read that agreement and make sure you may need to tell that third party, do not get rid of that information. Make sure you hold it, because any failure or spoliation can be imputed to you if you didn't take that step and you didn't prevent that information from being destroyed. Do you agree with that?
Yes, I think the trickier question is a situation where you have a third party that perhaps does not have any current legal obligation, contractual or otherwise, to maintain the information, and all of a sudden somebody out of the blue sends them a notice to preserve. I think that's a more difficult question. I don't think I have an answer to that.
Judge, I noticed you scribbling away there furiously a few notes. I'd love to get some of your reactions along with those of Stacy and Craig to a few of the points that Gail's hit on.
Sure. Actually, this was my grocery list, but one of the things I'd point out here is that applying proportionality in the context of preservation is really hard, partly because you're dealing with a moving target to some extent. In a situation where no complaint has been filed, you don't have a real firm idea of what the claims or defenses are going to be. In a pre-litigation situation, you don't have a court to go to get a blessing with respect to your decision about the scope of preservation. So you've got to make considered judgments about not only when the preservation obligation is triggered, but also what does it cover? You know, if I'm the plaintiff, have I thought about everything that I'm going to sue about? And if not, am I going to be precluded later from raising claims because I haven't preserved relevant information? So I think that's a major problem in applying proportionality in this context.
Okay, Stacy?
Well, I think preservation, when the duty is triggered, is a very fact-specific situation, and I think only the entity that is in that situation can assess. Did I get a letter threatening that this project is you guys are doing a terrible job, and the next step is that we're going to sue you, or did you get a text from a CEO that says if you don't stop this, expect that you're going to be dragged into court shortly. So while I don't think there is a clear-cut line exactly, when the duty to preserve, absent like getting a complaint is initiated, I think that there are certain, pretty basic cues that make you realize that, I think for, to preserve information and data that might be helpful to us, plus under, what you owe to the other side eventually, you would sort of understand when you need to take those preservation efforts. And I just wanted to say one thing in terms of if you're a third party, and you aren't contractually bound to have any kind of obligation to preserve, the concept of proportionality and it's vague, and I don't think if you are the entity that has all this information in your possession and your custody, and that you have some kind of relationship with the two parties or one party that's involved in litigation, I don't think you want to take the chance that you're, going to allow your overwriting to occur, or you're going to, dump all this stuff, because you might get dragged, and I'm speaking as a defendant's attorney, from a corporation. You don't want to get dragged into this lawsuit also, and you don't want to be the subject of a spoliation motion. So as much as there is proportionality and the duty's not clear, I tend to think that, until there are more bright lines, you're going to err on the side of caution, maybe negotiate what would be really relevant to the particular claims and defenses in the action, and not feel that you have to preserve, your universe of information that might not at all pertain to, a very broad subject matter. But I think, prudence and cautiousness is, I guess, my perspective.
Good. And you asked for the costs of that preservation.
Yeah, absolutely.
Great. 30 seconds, and then we're going to transition.
Preservation is more than a letter. Preservation is more than something that you got in a good form that you send out to your clients and say, okay, my butt is protected now. I've told them to do what they need to do. When you look at the cases of serious sanctions and preservation, they were not esoterica. They were people hoping that a case was going to go away. They generally knew what they needed to know to preserve, and they just made a studied decision, or more often, a completely oblivious failure to decide, failure to consider. If you stop and you really think about what may pertain to both your claims and the defenses of the other side, or vice versa, and you make a reasonable effort to identify the people who have that information and to ensure that that information is preserved in reasonable ways, you will be fine. But you have to do those things.
Thank you, Craig, and thank you everyone for your comments on this very important topic. Let's transition to collection. Okay, this is another sticky wicket in terms of competence, and there's a lot of different angles that could be covered. We're only going to use 8 to 10 minutes to do so. But Stacy, what highlights would you share just briefly about collection and competence?
Sure. So as we've been discussing all day, I think that the model rules on, competency in your representation, duty to protect confidential information, duty to communicate information are all rules, ethical rules that are involved in the collection process. And in establishing competency in collection is not just, as straightforward as it used to be. Now there are so many different mediums and modes and platforms on which people communicate. And you really have to have a checklist to determine, where is the information. I mean, of course, you want to check people's emails, but you now have to ask, on your checklist, do you communicate, do you transact business on an iPad? Do you do it on another kind of device? Do you do it on a mobile device? Is it a company-owned mobile device? Is it your personal-owned mobile device? Is there a container solution on the mobile device so that you know whether or not the company is in custody and control of your information? You also want to know, what other tablets. Are there any collaborative environments in which this, person who has information has put their information? A lot of times now in business we're moving much to a more collaborative environment where people can work on documents together, and they're not in one person's email, but they're on either a cloud platform or some kind of communicable platform where there's access by many. So you want to include that in your checklist. Does this person communicate through social media? Do they use Dropbox to store information? So in terms of collection, you have to have a real comprehensive checklist to determine where information resides that can be collected.
Stacy?
Yes.
I think you mentioning Dropbox, it's a very hot button item. How many of you routinely ask when you're collecting or seeking to ascertain the universe of relevant information, how many of you are asking whether the employees are using a personal cloud provider, a personal cloud application? Okay, we've got a few. Again, this one goes on your checklist, because how many of you are using, or how many of us use, Google Drive, Dropbox, Box, Jota Cloud, or any number of other personal cloud providers? Okay, it's a discovery headache, and for another time and another discussion, it is a titanic information governance headache with respect to trade secrets and other issues. We're not going to go there right now, but I just think it's important to emphasize this particular issue. Please don't let it slide through the cracks. Go ahead, Stacy.
Absolutely, and once you establish, where all this information and data resides, and you could be a solo practitioner, you could be part of a small firm, large firm, medium firm, corporation. Then you have to have appropriate means to collect the information, and you have to have concerns whether or not are these custodians are we collecting information from domestically, from the U.S.? Is there HIPAA information that we need to be concerned about? Are there consents that we need from this individual? Is this, regulated from a state perspective or another federal perspective? Is this consumer financial information that would be governed by FACTA? So there are all these concerns, and then if you're, dealing with some kind of litigation that involves data that resides overseas, you have to be sensitive to data privacy concerns. Am I trying to get data out of China? There's a strong federal trade secrets in China. Information does not come very easily from that geography. Similarly with Germany and with Switzerland, UK, the data privacy laws are very strong right now. There is going to be more comprehensive litigation. There's a directive and a regulation is going to be coming into effect. But you have to be sensitive to all these concerns, and your duty of competence is really to understand, what you're going to look for, what you're going to collect, where you're collecting it from, and you also have to assure the confidentiality of this data in its transmission. So collection is not as easy as it seems. There are a lot of concerns and considerations with collection.
Any other comments? Thank you, Stacy. Yeah, it's not as easy as going to the filing cabinet and making photocopies of file folders and documents anymore.
Yeah, let me add one thing, and I'm gonna be the one who harkens back to proportionality all the time. Proportionality is particularly difficult in collection. You would think that you could, for example, identify the most critical custodians and collect only from those custodians and process that information and search it. Part of the problem, and this lapses over into Craig's segment, part of the problem is whether you can segment the universe of information is going to depend in part on the analytical tools you're using to do the search. It may be that it undermines the validity of your search if you begin to make arbitrary cuts in the information that you're collecting.
And okay, go ahead, Stacy.
There was one other point I wanted to make, I forgot. There's also a difference between a self-collection and an imaging of someone's, hard drive. And I think, depending on the circumstances of the case, if you are going to ask an employee who might be the subject of who might be eventually a plaintiff in an employment action to select the documents to submit to the council, you're going to run into a problem. This person has no incentive, no motivation to turn over documents, which might be eventually potentially harmful to them. So you have to be careful. Self-collection is a little bit tricky, and I think, imaging is more on the expensive side, and certainly, costs are very factor in any litigation, but you might be safer, to have a vendor, or if you have some kind of tool to image a particular custodian, and then, as the judge said, to apply search terms to make the production more proportionate, or even the collection. But you have some difficulties and some risks in self-collection, depending upon what the claims are, what the defenses are, and you just have to be aware of that and make an informed judgment.
Yeah, and I'd say on that note, when you have a discrimination case, you don't want the alleged harasser pushing the data to counsel. You probably need to pull it. Interested witnesses, again, you're going to want to use your discretion as counsel to pull that data, like you say, imaging or at least hand-holding, rather than giving them the discretion to push it. You'll know what's right, but that one that I just described with the discrimination context and an alleged harasser, that definitely doesn't meet the laugh test. And if you allow the alleged harasser to pull the data out themselves and then push it to you. I'm going to turn over the time to my distinguished friend here. I sound like I'm in the House of Representatives, which sounds like I'm lying. I'm not, because he is distinguished. He is my friend. I'm going to let you transition.
You can see the screen if I do this. Do you mind?
Go ahead.
And I hope this doesn't complicate the microphone.
No, he's not going to use that handheld because it doesn't work worth a darn. So I'm going to give you guys a break.
It doesn't work, but it's a good try.
Let's see if
Check.
Here you go, Craig.
No, I'm good.
Okay.
We all know what what GIGO means. It means garbage in, garbage out. What we get out of a technical system is only as good as the quality of what we put into it. We talk about a lot of things in e-discovery, but we don't talk about quality. We don't care about the quality of e-discovery. Nobody stays up working, gee, did I give my opponent all the stuff that he or she really needs to do a good job on the case? Any one of you ever had that anxiety? Not generally speaking. And let me digress for just a moment in the context of this. I have to believe that there's some of you right now who are frantically writing down, you need to do this, you need to do that, you're hearing vocabulary, you're hearing this, you'll know to do this at that time, you've got to not let the fox guard the hen house. You hear all of these things. And half of your brain is saying, why did I come to this seminar today? Why do I need to know all this stuff? You know, dental school is still an option for me. I'm young enough yet. If you will take the time to learn the foundation fundamentals, you don't have to remember all the checklists. You don't have to remember all the directions of what to do. Because if you can devote a couple of days to learning the fundamentals of the information technology that pertains to e-discovery, you will have the system internally to be able to understand this stuff, to be able to generate these checklists in your own head, and to make defensible decisions. So don't try to learn this as a checklist. Make the determination, and I'll talk about that later today, to learn the fundamentals. So we don't talk about quality, and yet I feel we need to talk about quality and quality out, because if we look at the quality of search, if we look at the level of competence in search in e-discovery, we might be very surprised by what we find. It's not at all what we think it is as lawyers. Now, this is a very small part of a much longer presentation that I call Spoiled and Diluted, the Shakespearean Tragedy of Search and E-Discovery. You won't get all the Shakespearean references. I mean, you'll understand them, but you won't receive them today. I call it Spoiled and Diluted because we have all been spoiled by tremendously powerful search tools in our lives. As lawyers, we have Westlaw and Lexis, and when we go to those tools and we run a search with whatever keywords pop into our mostly empty heads, and we get the case we were looking for, we don't go, thank you, Lexis, thank you, Westlaw, thank you for the editors, the doctorate people, the fact that all of these opinions have been written by people with doctorate degrees like Judge Francis, who use very precise language, and we work in a very precise realm and ontology and tautology of language, and we all know where to look for the names of the lawyers and for the case sites and key sites and the name of the justice. We have all that information. We don't say, boy, thank you for making it easy for us to give it sometimes a very bad search and get the right answer. We say, damn, I am good at this. Same way with Google. Google has so given up on us in terms of search is they basically look at the wrong searches we put in. They've seen so many people put in the wrong search and then they get what they ultimately want that they don't even bother to tell you you're making a bad search anymore. They just show you what you're looking for. They make us feel like geniuses, but in fact, it's not really that easy. There's a lot that goes in behind it. And you begin to peel off the layers that show you the machine underneath when you start dealing with electronic discovery and search. I want to bring you to the lovely hills of Northern California and San Francisco, where some years ago they decided they would build a public transit system. They had one, and it worked pretty well for a while, but if any of you have ever tried to actually board a cable car, you know that it's populated by tourists, and you can't really get around very practically. So they decided they would build an underground railroad, a subway system. Well, as we all know, the western cities are not as experienced as the older cities of the East, like Richmond being one of them. And so they didn't learn the lessons of the East Coast cities with regard to building a subway system. And let me share this important lesson with you, because I think it's an important takeaway about it. When you're building a train system, the trains, should stop before the tracks end. Good idea, right? Well, they didn't get that at first with the Bay Area Rapid Transit System, so they had these trains going off the end of the tracks, and people got hurt, sadly, and who knew? Litigation ensued. Nobody saw that coming, but actually there was some good that came out of it, and two very smart information researchers named David Blair and Emmy Marin did a study. They went to the lawyers and paralegals who had worked with collecting a lot of documents for purposes of this litigation, and this back in the very early 80s. They said, hey, let us digitize your documents. Of course, that was Star Wars at the time. And let us go ahead and give you keyword search tools. And you can search with Boolean connectors and proximity searches and fuzzy searches. They could do all this wonderful stuff that we take for granted today. And they said, we just want you to do one thing. We want you to search through these documents. And by the way, I should tell you, it is by today's standards a very modest collection of about 40,000 documents. Today, we wouldn't even think much about the challenge of that in the days of tens of millions. And so they asked them, please search the records through the keyword search mechanisms, and we want you to tell us when you believe that you have found 75% of the relevant documents in the collection. Well, the lawyers and paralegals said, this will be a walk in the park. We've worked with these documents for years. We know the language in them. We know everything about them. So if you compare that task to the tasks we have in e-discovery, it's no comparison. That's much, much easier. Imagine if you were only trying to find the things you already knew were there. Well, they did the work, and for those of you who've ever looked into this area, and many of the stalwarts, those of us who live inside the Sedona and Georgetown and EDRM bell jars and so forth, we know that when they did the work and they looked at how many of the relevant documents they actually found, it was, what do you guess? What do you guess they got? 15. Close. It was 20%. So these experienced lawyers in this lay-down process missed 4 out of 5 of the relevant documents. Well, the interesting thing about that is that it hasn't changed much in recent years. A first-pass manual search is still going to only turn up about maybe 1 out of 5 of the relevant documents, about the range of 20% using plain old keyword search. And the reason for that is because we use a lot of different phrases to say the same thing, and even how we read a document is influenced by our point of view, and the words that we use are influenced by our point of view. And so that's one problem we face as we try to approach the challenge of search and e-discovery. Another is a huge problem when we have machines searching for information. I grew up with an old book called Why Johnny Can't Read, but the book we need for the new millennium I call Why Sergey Can't Spell. And I refer here to Sergey Brin. Sergey Brin is one of the co-founders of a small search engine company out on the West Coast. And I'm going to bring you out again to the West Coast. I'm going to bring you back to September 15th of 1997, almost 20 years ago. And we're going to go on down to the beautiful campus of Stanford University in Palo Alto, California. And there we are standing outside of the William R. Gates Computer Sciences Building. And it's just a testament to the fact that Bill Gates had been so rich by the time this search engine came around that he not only had the time to earn the money, but to endow and build the building. So, as we go inside, there are 2 young unknown graduate students, Larry Page and Sergey Brin, and they're very excited because they've perfected a new technology for searching the burgeoning web. They've had this idea how they could use people's linking to things as a means to organize this web. And so they're sitting around with a fellow graduate student named Sean Anderson, and they're thinking, you know, the name we use, it just doesn't sound serious enough for making money from this tool. And does anybody know what that name was? Anybody recognize this? Yes, indeed it was. It was Backrub. That's the first person, Casey, congratulations, the first person who's ever got it. It was called Backrub, and they didn't think that sounded serious enough, so they went looking for another name. And somebody said, oh, you know what? My professor in my math class, he used this great word. What was it? It was Google. 10 to the 100th power is called a Google. And they go, that's great. You know, mind you, the search competitor was called Yahoo at the time, so this was relatively serious. So they said, let's do that. Sean, why don't you go and register this name on the internet registry? And Sean said, you bet, guys. Well, Sean is a fine coder. Works for Microsoft, very fine man, but better coder than he was a speller because he didn't know how to spell Google. And instead of registering this, he registered this. And the rest is history. It was a mistake. The point I'm making is that misspelling is rife, but it is not rife only among software engineers in Northern California. No, I served not long ago as a special master in a case called In Re Seroquel, a case involving litigation over an atypical antipsychotic drug. Apparently, there are typical antipsychotic drugs. This is an atypical antipsychotic, and it was made by a company named AstraZeneca that got into some trouble in the Middle District of Florida for or failing to meet its obligations in e-discovery. And in that, we were looking at why it was that searching their own records at AstraZeneca, they couldn't find records on Seroquel. Well, it turned out that despite being composed of some of the finest minds of biochemistry and pharmacy and pharmaceuticals and medicine, with Nobel Prize winners and all that good stuff, they couldn't spell any better than the rest of us. Turns out that they were more prone to misspell the name of the product that they had coined and created internally than they were to spell it correctly. So if you were looking for Seroquel spelled like Seroquel, you were missing most of the references to Seroquel. Lesson learned: when you are searching for competency, you need to look at variations of search. And finally, and I'm saying finally because I hope to be able to keep this short, finally, I want to talk to you about something called indexed search. When you search with e-discovery, you may be thinking that to the extent you give it any thought at all, that it sort of spiders out, kind of like you imagine Google might work, which is you put keywords out there, they go into some magic hopper at IT, and they walk around the building and through the computers like little tiny insects, and they check each file. Do you have this word, by the way? Knock, knock, knock. No, you don't. Okay, I'll move on to the next one. It doesn't work like that at all. What happens instead is that if we did the search like that, it would be so impossibly slow to check each one. We wouldn't get searches done for days or possibly weeks. So we do something called index search. Well, to understand index search means to understand that even though small children can read, no machine can read. Okay, not even the venerable Watson can actually read. They can be programmed with rules. And that's what we do did I hear, was that my click? Okay. That's what we do. And we use rules to do something called tokenizing. And in that process, we say, are you more than 2 letters? Are you flanked by spaces? And are you one of those words that we're told you should not index because it'll gum up the work, so-called stop words. And so we do this to words as we check it. The machines use these rules, and I'll run through this very, very quickly until we get to a word like from. And yeah, it's flanked by it's 2 letters, it's flanked by spaces, but it's a word we've been told to ignore, a so-called stop word or noise word. It doesn't go into the index. It cannot be searched, not even if you put quotes around it. And then we get to a word like e-discovery. Computers see hyphens as spaces. The E is then not going to pass the 2-letter rule, and very likely, depending upon what indexer you're used, you will not have e-discovery as a word searchable in e-discovery. Think about that one for a moment. So we build these indices, and then we run our searches against the index. And that works pretty well with certain kinds of files. Maybe it works well with plain text. Maybe it works well with Word documents. Maybe it works okay with the plain text of a PowerPoint, and so on. It doesn't really work at all with an Excel document when you're looking for numbers, because the numbers really aren't in there. They are calculated and so forth. And we go on. Each one has to be considered as to whether it will work. And we get to things like password-protected documents, and they simply fall off the table as if they never existed. So the documents that are often most critical, most targeted, most desirable as evidence because they've been locked up, perhaps it's highly confidential, those things are simply missed generally in e-discovery, and we may not be competent enough to know it. So to close, imagine you are a barrister in jolly old England, and in comes a brand new client. And your client is none other than the Bard on Avon, William Shakespeare, and he doth be pissed because Eddie de Vere, the 17th Earl of Oxford, is going all around the old city of London, biding his time with the wenches, whispering to be or not to be in their ear, which in that day was sort of your place or mine. And so he wants to sue. You didn't know you were going to know this today. And the thing is that you're not, I've already messed this up. Let me say it this way. I'm in a bit of a hurry. I'm sorry, Phil. Eddie de Vere's lawyer calls you, and he says, look, why don't we search Eddie's computer? If we find that, what was that phrase? Oh yeah, to be or not to be, we'll talk settlement. But if we don't even find to be or not to be, it's not even mentioned in his computer, you'll dismiss. Are you going to make that deal? No, you're not going to make that deal because this is the noise list for DT search. Good piece of software, the backbone software of many modern e-discovery tools. I don't single it out because it's bad. I single it out because it's very good and thus very commonly used. If you look at the noise list, the excluded things, you'll of course have all single letters and numbers excluded, but to be or not to be, all of the words of that most famous phrase in the English language are noise words. It cannot be searched at all. The system won't say, oh, you can't search that. The system will simply say, we didn't find anything. And so you need to know that about your systems, and you can't search in quotes. And I think that I will just leave it there, and thank you very much.
So anyway, we'll skip to the end of this. We do want to show you a couple resources, and as you can tell, Craig does an excellent job, and the good news about Craig and our other speakers is that they'll all be up here the rest of the afternoon. Each of them has their own segment. But as they all said, we have very much to work, quite a bit to work on in terms of being competent in all these issues. I'm sure not all of us can say, oh, I do this every time I have all these things down pat. But we can work, like you would suggest, to get competency in each of these areas. Any closing remarks before we finish up here? You'll get your closing remarks in your next segment. Please give us a loud round of applause for them.
So we will be taking just a 5-minute break to get everything set up. So if anyone needs to step outside, feel free to do so.